Attorney Francine Ward, and welcome to my very first Google Hangout Air webinar. I am so glad you guys took the time to join me today, and my hope is that when you walk away from here in 30 minutes, you've got a little bit more information that can take you into the new year and get your new business or your existing business off to an amazing start in 2015. So I'm going to talk for about 20 minutes or so. We've got 30 minutes. I'm going to talk for about 15, 20 minutes, and then I'm going to open it up for questions. So you can write your questions in chat, and I will be periodically checking it, and then I'll come back to the questions at the end. Okay? So let's get started. Well, you know, this technology, when it's working, there we go. Okay. So the very first tip we'll talk about, and I'm going to share with you three tips, three must know legal tips. And again, if you're a business owner, an entrepreneur, a content creator, this, in fact, may be one of the very best webinars you've ever attended, especially because it's free. So, tip number one, have clearly written agreements with everyone you do business with. Now, I've had people constantly ask me, Francine, why should I have an agreement, especially if I'm entering into a relationship with somebody I know, with a friend. So here, let's take a look. Why would you have clearly written agreements? Number one, it clarifies the expectations. It clarifies the terms of the relationship. And the truth is, you may be thinking that it's one thing and they may be thinking something else. So it in fact clarifies the terms. Let's say someone hires you, excuse me, let's say someone hires you to design a website. There may be website designers on the call. So if they're hiring you to do that, you want to make sure you are very clear as to what's expected of you and what's not expected of you and what you're going to get for that. It puts everybody on the same page. You know, all of you are thinking exactly the same thing as opposed to one person sees one thing and another sees another. I'll give you a great example. When I was in law school, in fact, practically every single first year law student has this case. It's a case that deals with chicken. And I'll tell you, it is a case that even today I remember so clearly when it comes to everybody being on the same page and that we don't always see things the same way. This case had to do with chicken. One of the merchants was selling chicken and the other wanted to purchase chicken. So they wrote in the contract simply the word chicken. Well, at the end, when one purchaser handed over the chicken to the one who was buying, he in fact gave roasting chickens, but the one who was selling, in fact, was thinking fryers. Now, anybody who's a cook knows that there's a roasting, you know, roasting chickens are not the same as fryers. So they ended up having a problem because one was thinking one thing, another was thinking another. It's sort of like you have a glass with some liquid. Some people may see that glass is half full, and some people may see that glass is half empty. You want to be on the same page as the person you're entering into a business relationship with, so you have clearly written agreements. Another reason is you want to memorialize the terms because the truth is we forget. Most of us today are really, really busy. And I got to tell you, some of us are beyond the age of being considered young. So if you don't put it in writing, it is so easy to forget what you did in the next moment. I got to tell you guys, you know, unless I'm looking at my date book, I don't even remember what I did yesterday. So you want to make sure it's memorialized in writing. And the fourth reason why it's really important to have clearly written agreements is because what if? I mean, worst case scenario is that you have to go to court and you have to sue somebody because they've taken something from you that doesn't belong to them. What if you have to do that? You want to have a paper trail. Because if you don't, it's going to be really hard for you and it's going to be hard for any attorney that works with you to make a case for you. So, contracts with who? Who are some of the people that you might want to consider having an agreement with? Well, your clients. You want to make sure you have an agreement with every single client you do business with. You want to have agreements with your employees, whether they're part-time employees or whether they're full-time employees. You want to have something in writing with those people. With your contractors, any independent contractor, and some of you I would imagine on the call are in fact independent contractors. You design websites, you design logos, maybe you write ebooks, or you take videos, you take photographs. Either whether you are a contractor or if you contract with contractors, you want to have something in writing. Again, it just clearly defines the terms of the relationship. You don't want somebody coming back saying, well, I thought that I was supposed to do this, or I thought I was only being hired to do this, and now you're asking me to do something else. If it's in the agreement, then it's clearly defined. Next person you might want to consider contracting with are your collaborators. So I've got a client the other day who came to me, and she is a big speaker. She does speaking and coaching, and she wants to collaborate with another speaker and coach in writing an ebook. That's wonderful. But we needed to make sure that relationship was reduced to writing. So they're collaborating with one another. We created a contract for her. Absolutely. This is one of the problem areas because very often people think, well, it's my friend, or it's somebody that I like, or it's somebody that I know, and I trust them. Well, when it comes to business, there is no trust. When it comes to business, it should be in writing. Then you can sleep a lot easier because you know that you've done the right thing for yourself. Any business partners you might enter into a relationship with, you want to consider having agreements with them as well. Shareholders, members. So let's say, for example, you have formed a corporation. And in a corporation, you may have shareholders if you are, if you've got shares, which in most cases you will, if you've got a C corporation and possibly an S corp. You want to make sure that you have agreements with those people. Let's say, for example, you have a contractor who you really can't afford to pay at the beginning of the relationship, but you've agreed to give them in exchange for their services some stuff. You absolutely want that agreement to be in writing. You also want the bylaws to be in writing, and you want the any shareholder agreements to be in writing. Likewise, let's say you don't have a corporation, but let's say you have a limited liability company. And in that case, they may have members. You want to make sure you have an agreement with those members. Generally, the operating agreement is what you will have. And anyone that you share creative ideas with, I don't care who it is. If you're going into a meeting, a business meeting, and you're about to share some ideas with anybody, it could be a potential investor, it could be someone who is going to, maybe it's a studio, maybe it's a network, maybe it's a producer, maybe it's just someone who can help you market your idea. You still want to make sure you have that idea, you have it reduced to some kind of contract. You want a written agreement with anyone you share your creative ideas with. So what are some of the types of agreements that you might consider having? Well, some of them I've already mentioned, but without question, you might consider a work for hire. So if you're now, if you are a contractor, even though, and I know a lot of contractors know this, but even though the general rule of law is that the person who creates the work of art is the one who is the owner of the copyright, for example, you still want to have that in writing. Because, even if it ends up that you're correct and you win, if you go to court, you don't even want to have to go to court if you can avoid that. So you want to have everything in writing. So work for hire might be one of the types of agreements. And guys, this is just a short list. There are so many different types of agreements. Actually, any kind of relationship you can think of can be reduced to writing. So there are confidentiality agreements, sometimes called NDAs. There are website development agreements, website terms of use, licensing agreements, employment agreements, collaboration agreements, operating agreements, which would be used if you have a limited liability company, bylaws. Bylaws are a form of agreement, and shareholder agreements. Again, these are just some of the many, many types of agreements that you might want to consider having. Tip number 2. Read and understand all documents before you sign them. Now, I can't tell you how often I tweet about this or blog about this or just talk about it in general. I cannot begin to tell you how often this topic comes up, and yet still people enter into relationships without reading and understanding the agreements they sign. I mean, I'm just amazed. And more often than not, I'll have people come to me saying, Francine, can you help me get out of this agreement? Or, what did I get into? But once you sign it, I'm not saying it's impossible to break an agreement, but it becomes a lot more costly because any lawyer that's going to have to fight that for you is going to really need to come up with some pretty creative legal maneuvering to get you out of an agreement you signed. So the bottom line is it's better to make sure you understand what you signed before you enter into the relationship. So why don't people read agreements before they sign? And some of you are probably thinking, I don't read agreements before I sign them. How come? Well, one of the reasons is because this is what most contracts look like. Now, I know it. I'm a lawyer. I've drafted them, but this is what most contracts look like. They look like gibberish. To the average person, it's like, oh my God, what am I looking at? And this is what most agreements look like. Or they look like this. The font is so tiny, and there's this language you just clearly don't understand, but the font is so tiny, it's like, who can understand that? Not even some lawyers can get through this kind of stuff. And some other reasons that people don't read agreements before they sign them, or any document. I say agreements, but clearly I'm talking about documents because sometimes it can be an agreement and you don't think it is because it doesn't look like one. It might look like a letter. It might look like a napkin that somebody scribbled some terms on. An agreement, the law basically says that you have a valid contract as long as there is a clearly defined offer, there is an acceptance and some kind of consideration, something in exchange for something else. So you could scribble it on a piece of paper, and as long as all the terms are there, as long as it's clearly understood and the other person accepts it, it could be a contract. Some other reasons that people don't read agreements or read documents before they sign is that they're just too long. And I mean, I'm sure all of you have at some time or another been given a document that is just so lengthy. I mean, if you've ever purchased a car, or if you've ever leased a car, if you've ever purchased a home or leased a home, those leasing agreements are pretty lengthy. If you've ever purchased insurance, those agreements are lengthy. And what about our very common terms of use? Today, those terms of use are so long. So no wonder people don't want to read them. They're too long. Another reason that people very often don't read and understand agreements before they sign is they actually trust the person. I mean, how many of you have ever signed something that someone put in front of you simply because you trust them? You thought, okay, I trust that person. Maybe it was your spouse, maybe it was your best friend, maybe it was your partner, maybe it was just somebody you know and you like, but you trusted them. That's why you didn't require that there was something in writing. Another reason that people don't read and understand agreements before they sign or any kind of document is because they're just too busy. They are just too busy to they are just too busy to they're just too busy to read it. They just say they can't. They just don't have the time. Another reason is you feel really pressured. Very often you just feel so pressured that you just don't have the time to do it. You feel like, I have to do it. I have to read it. If I don't, it's like you feel like you have no choice. So I absolutely understand that. And another is that you feel like you have no choice. So why should you read them? Whether you like it or not, whether you understand it or not, you should read them because whether or not you do read them, when you sign it, you become liable for it. And that's the bottom line. And then we go to tip number 3. Tip number 3. Tip number 3 is protect your valuable intellectual property.
So, what is intellectual property? And sometimes you'll hear people talk about it in terms of IP for intellectual property. Well, intellectual property is anything that you create with your own mind, anything you create. And some examples are copyrights, trademarks, trade secrets, patents, and rights of publicity. So, a copyright, the a copyright is legal protection afforded to any original work of art or authorship that's been reduced to a tangible form. A trademark is basically a source identifier. It's a word, a phrase, a document. I'm sorry, it's a word, a phrase, a design, or a combination of any of those things that, in fact, identifies the product and service from another product and service. A patent protects inventions and sometimes designs and sometimes utilities. There are three types of patents: plant, utility, and design patents. A trade secret basically is information that gives you, as a business owner, a competitive advantage over your competitor. And it's generally information that's not known to most people, especially not to the public. And rights of publicity is where you have the right to protect your own image, your likeness, your demeanor. You have the right to prevent someone else from using your name, likeness, or image and monetizing it without your permission. So, why would you protect your intellectual property? Well, number one, because you probably invested a lot of time and money in creating it. That's what I'm thinking. For most of you that are out there creating, whether you've created a business and you've come up with a brand, whether you're creating content, whether you're creating products, you've invested time and money in the creation of that content. Uh, the second is it's really a valuable asset. You know, a lot of people think that they make light. In fact, even the most creative person, it's very interesting to me how even the most creative person sometimes doesn't value what they create. They treat it like it's nothing. And in fact, your intellectual property can be your most valuable asset because if correctly monetized, if properly monetized, you can make a lot of money. I mean, great examples right now. When Facebook first started, there's no way that Mark Zuckerberg thought it was going to take off in the way it did. And now it's a company that's worth millions and millions of dollars. Likewise with Apple, likewise with Microsoft, likewise with Wendy's hamburgers. You know, none of these companies, when they started, did they think it was going to be anything, but they started with an idea and that idea was taken to another level, and all of those companies are now valuable assets, as is all of their intellectual property, their trademarks, their copyrights, trade secrets. For example, Kentucky Fried Chicken. You know, their recipe is a trade secret. No one except people with a need to know actually know what's in that recipe. So it's a valuable asset. Why do you protect it? Because it's a valuable asset. And number three, if you don't protect it, I can assure you that someone else will come along and do it for you. So here's an example. I have a client who waited, who had this brilliant idea for a trademark. And she hesitated. She did not want to, for whatever her reason, to move forward with the registration. Well, she happens to be a speaker and a coach, and she was doing programs talking about this brand. And in fact, someone took the trademark and registered it before she could. Now, she could fight it because she's been using it for a while, but it's going to cost her because she was slow to file that application. So again, if you don't protect your own intellectual property, believe me, someone else will come along and do it for you. Okay, so how do you protect your IP? Number one, you want to avoid inadvertent transfers. What do I mean by that? Going back to those contracts, you want to make sure that you know exactly what you put your name on. Anytime you put your John or Joanna Hancock on a document, whether it's a letter or something that actually looks like a contract, you want to make sure you've read it and you understand it. Because it becomes really easy for you to give away your intellectual property without even knowing it, simply because you've signed an agreement. I have a client who just got a deal with on a reality show. And I have to tell you, those contracts literally try to take every single thing from you that they possibly can. The average person just desperately wants to be on a reality show, so they don't read them, those agreements, and they just sign off on everything. And then after the fact, they see they've given up their firstborn, and they can't imagine why. So in this particular agreement, because my client has a lot of leverage, she's a pretty big name person in her industry, and she came to the table with a lot of leverage. In fact, they came to her. So we were able to negotiate terms where we kept her intellectual property. We were able to keep a lot of things that the contract initially wanted to take. But the bottom line is, you want to read those agreements, because it becomes very easy for you to inadvertently give away your rights without knowing it. And I will tell you this, most agreements today, pretty much every agreement, there are of course exceptions, but pretty much every agreement you get signed today on some level has intellectual property law implications. Next thing is, how do you protect your IP? You want to register your trademarks. If you have trademarks, if you've got a creative design that you use for your logo, for your business, if you've got the name of the business that you use on all of your products and services, if you've got a logo or a combination of any of those things, a phrase, a slogan, if you've got a distinctive trademark or something that rises to the level of a protectable trademark, you want to register it. And of course, the key is you want to make sure it's something that can be registered, which is why, unless you know what you're doing, you probably want to talk to someone who understands trademark law. But the bottom line is you want to register those trademarks. The second thing is you want to register your copyrightable works. If you're creating content, so if you've written books, if you've got articles, and this again must be original content. You've got articles, if you've got if you've created videos, DVDs, all kinds of creative content, you want to consider protecting that copyrightable work. You want to use appropriate symbols. If you've got copyrightable work, of course you use the C in the circle. If you've got a trademark that you've been using, and you know, because you've done a comprehensive search to make sure no one else has used it, and you filed that application already, I'd start using that TM. TM for trademark, and if it's a service mark, you use an SM. It's the same thing. An SM is a trademark, but usually we apply that to service companies. Like if you've got an accounting firm, a law firm, a coaching service, if it's just a service and you've got no products attached to it, then you want to use the SM. At no point, and hear this, at no point are you allowed to use the R in the circle unless you have a valid registration with the U.S. trademark, the U.S. Patent and Trademark Office. So the R in the circle can only be used after you've received your registration. But before then, if you've done your search and you've been using the trademark, put the TM on it. And that lets the world know that you actually claim some rights. Let me say this, however, I really stress the point that you should do a search to find out if no one else is using it. Because sometimes people don't know any better, and they slap that TM because they think they could or they should, and they really don't have any rights in that work. So again, you want to make sure you know what you're doing, but if you filed an application and you know that no one else is using it, you want to go ahead and put that TM on there. You want to monitor your intellectual property. And even if, in fact, you want to monitor it before as well as after you have a registration. But especially after you get your registration, let's say, for example, your trademark registration, you want to make sure you monitor your trademarks. Because if someone else starts using it after you have a valid registration and you don't do anything about it, you don't let them know that you, in fact, are the legal registrant, down the road, you possibly can lose your work. So you want to monitor it. And if, in fact, someone is using your trademark, you want to let them know in a pretty nice way that they need to stop. And finally, how do you protect your trademarks? You want to make sure you adhere to any post-registration requirements. You know, a lot of times people think after they get their trademark, it's done. This is it. I don't have to do anything else, but that's not true. In fact, a trademark lasts forever, unlike a copyright or unlike a patent, but a trademark lasts forever as long as, number one, you have to do certain things. The first thing is you have to file what we call a declaration of continued use between your 5th and 6th year after registration. You have to renew your registration every 10 years after it's first registered. You have to make sure that, again, you want to monitor your trademark, make sure no one else is using it, and if they are, you want to let them know in a nice way that you are the owner and that they need to stop. So that's it. I have a little time I've allotted for questions. Let's see. Okay. Let's see if there are any questions in the chat box. If anyone has questions, go ahead. Let's see. Are any questions? I want to make sure I don't miss them. I don't see any. Okay. Well, I thank you so much for joining today. I'm attorney Francine Ward, and this was 3 must-know legal tips to help you get started with the new year. Again, take good care, have a wonderful holiday, and good luck on your business in 2015. Bye-bye for now.